All right, good morning, folks. We're recording from my basement. I was trying to get over to the university to do some recording, but apparently yesterday someone there had tested positive with the virus, and that prevented us from even getting access to the to some of the buildings over there. So this is an unfortunate time. What's going on, and I think all of us just have to just do the best we can. Oh, in the court system, things have just gotten pretty much as bad as well. We can't get any jurors. You're not going to get 300-400 people to congregate in a room anymore in order to wait to be selected for jury service. So this situation is affecting all industry, all walks of life, and I think it's just something that we have to just just learn to deal with a little bit. So we've been instructed by the school to try to the best that we can, try to get our course shifted to online. And I've tried to do that here. So what I'm going to be doing is I'm going to put a lot of our course on, I'm going to film it, and then I'm going to put it up on YouTube, and I'll send you guys the link as to how you can get it. And that will have the lesson. I'll be using my PowerPoint. And then I'll be changing most of our tests to a different format. Format will be mostly essay answers where you're thinking instead of pretty much multiple choice where you could just go to the PowerPoint and just do the answer. All right, so it'll be a little challenging. Anyway, this one is going to be in two parts. This particular one here, I just want to go over the tests that the quiz that you guys had, and then the next one, it will be the next lesson, which is the information I already sent you, which is the waiver. I sent you information on an article on liability waivers, and I also sent you some cases that I wanted you to look at as well. I will incorporate with the waiver discussion. So for now, let's just go over this exam a little bit. So I'm always glad to see that when I put out an exam that some people do very, very, very well. Some people have gotten 99 on this exam. Other people have gotten as low as 50. So let me just explain to you the reason why. I don't believe it's because there's any lack of knowledge in terms of those people who didn't do well. But I told you before that the way I design my tests is that, well, this course is designed to teach you to read with understanding. So you're going to see, and you could see now in this exam, because I sent you the answers already, that there's a lot of questions a lot of you folks would have gotten right if you had just read the question properly. And again, I go back to what I've been talking about in the law. If you're going to be involved in the law, if you're going to be a paralegal, if you're going to be an attorney, every word is important and every word means something. So let's just go through this exam. So the first question was, give me 3 examples of self-executing contracts. I told you guys that a self-executing contract was those things that we do on a daily basis that we don't even think about, that don't even pop into our heads. We do them without thinking. And as the examples I have here, ordering a coffee at Dunkin' Donuts, going through a car wash, buying a newspaper at a corner store. Those are the things that we do without thinking, without negotiation. When you buy a coffee at Dunkin' Donuts, they tell you it's cost $1.50. You don't say, well, can give it to me for $1. That's negotiation, okay? That's more involved. Some of you folks have written down, doing a warranty or paying a phone warranty or paying doing a credit card bill. That's not what I'm talking about, okay? Those of you who were present in the class when I gave you the example, what I'm talking about is the most simplistic of everyday actions that actually go on without any thought, okay? So again, some questions I gave partial answers to, partial credit to, and some got full credit, and some got no credit. Okay, so again, the most simplistic of actions. Okay, the next one. When someone says there's an implied contract of good faith in every contract, what does that mean? Almost everybody got this right. Okay, this obviously means exactly what it says. That in every concept, there's an inference, an implication that each side to the contract will do and will live up to the bargain that they entered into, that they will do their respective part of the contract with respect to their requirements. Okay, what might be some long-term contractual issues an airline manufacturing company might have to consider before entering into a contract to supply an airline with new planes for the next 30 years? Most people got this right also. We had a lengthy discussion about getting involved in long-term contracts and the result of that in terms of how that can bind a party to the contract, unreasonably so, going forward in the years ahead. Okay, one of the surest ways to avoid problems with contracts is to use written contracts for performances that can be completed in a short period of time, and use oral contracts for performances that will take a long time to complete. This is simply reversed. That's all I did with this. I just reversed this again, so you have to read it. Okay, the surest ways to avoid contracts is to use a written contract for performances that will take a long period of time. Okay, oral contracts are always can always be used for contracts that will take place. That can be completed in a short period of time. And the period of time cutoff we have generally is a year. So if the contract involves work to be done over a period of a year or more, it always should be in writing. If it's a year or less, it can be oral. But in most instances, I suggest that you have it in writing. Okay. In order to establish an enforceable contract, there must be an agreement between competent parties based on the genuine assent of the parties. I put absent. Again, you're not reading. If you got this wrong, you simply didn't read it. It looked like it was correct, but it's not correct, okay? Supported by consideration. There's two things. That does not coincide, okay? The correct one is that does not contravene. That is not against the principles of law and public policy, okay? I had here that does not coincide principles of public policy. So there are two words in here that were totally wrong. And because the overall answer looked like it was correct, most of you just said, or a lot of you just said, it's correct. Again, you did not read it, okay? The nature and intent of a contract can be determined not just from its words, but by also considering the acts and conduct of the parties, okay? This is true, okay? So if you, again, the way I grade, if you got that right, if you said true, because it is true, you got half credit if your answer, your explanation didn't make any sense, all right? So there's two ways to still get credit here. One, you get full credit for a correct true or false answer and a correct explanation, okay? So the explanation here is correct. And there must be an agreement between two or more parties who manifest the intent to be bound by the definite terms of the contract. The example, I will pay you some money when I choose for a car would not be considered a contract. Well, oh, sorry. Let me just... One moment. Okay. So the best example you have of this was someone's actions explain the terms of a contract, and you can take that in consideration, is right here. Bill and Harry agree that Bill will paint Harry's house for $200. Bill goes to Home Depot, purchases paint, and commences to paint Harry's house. Okay, Bill's conduct, what he did, okay, verifies by implication or by inference, however you want to say it, the existence of a contract with Harry. Okay, so if it turned out that, Harry did not want to pay Bill because he was dissatisfied with the job that Bill did, and Harry tries to say, we never had a contract, okay, one of the ways that Bill can prove that the existence of a contract is to show, I went to Home Depot, here's the receipts, I bought paint, okay, And I started to paint the house. Here's me painted the house inside. These are pictures I took. Okay, that proves, okay, by implication, that there was a contract with Harry. Okay, so only question now is going to be the value of that contract. Okay, first of all, Harry's going to become he's going to have a lot of problems with the court in terms of how the court relates to him, because you have to come to court with clean hands. In other words, you can't stand before the court and lie. Okay, for Harry to say there was no contract and this guy was in his house painting it, okay, it would be a bold-faced lie. So when it comes to the $2,000 or the determining the value, Bill can obviously get one or two other estimates by other individuals in the who do that type of work in the neighborhood, give that to the court. But Bill can also sue Harry for most likely attorney's fees, all right, for him wasting his time to come to court. But the bottom line is that you can prove a contract, and a contract can be proven by inference by looking at the conduct of the individual parties. Okay. Number 7, James offered to sell his 1990 Corvette to Harry for $10,000. Harry said, "You have a deal for $7,000. So I said to underline any and all that are correct. So when you look at this, James offered to sell his 1990 Corvette to Harry for $10,000. Okay? Harry says you have a deal for $7,000. Harry just rejected James' offer because he did not take it for $10,000. He rejected the offer. Okay? Harry basically said no. Right? Harry said, "I'll give it to you, I'll buy it for $7,000. Harry just made a counter offer to James. Okay? He rejected the offer that James gave, and he made a counter offer. So Harry just became the offeror, and James just became the offeree, because it's now under this one, it's now up to James to accept the counter offer made by Harry. Okay? Now, so B and C are definitely right. Okay? What about D? Harry just made a conditional offer to James. Okay, so if you got this answer, because that would have taken some thought, if you got that correct, then you got credit for it, okay? Because it is also a conditional offer. A counter offer is almost a conditional offer. In other words, Harry just made a conditional offer to James, meaning that Harry basically said, if you give it to me for $7,000, that's the condition you have to meet, then we have a deal, okay? So B and C are the correct answers, but if you got D, that was correct as well. You obviously did not get credit taken away if you did not put D, right? Okay, number 8, Harry tells Susan, "I'll pay you $100 a month if you let me park my car in your driveway." Susan agrees. Is this a contract? Yes or no? And explain. Okay. So this is a contract. Okay. It's specific with respect to the expected work, the duration, and the costs. And Susan agrees to forbear the use of her own driveway in reliance on the expected payment from Harry. Okay. In other words, there was detrimental reliance here, because Susan agreed to give up the use of her driveway. She agreed to not to do something that she has every right to continue to do, right? But some people argue that this was an agreement, and if your argument made sense, because there could be an argument both ways, I gave you credit for that as well. So everyone got credit for that particular question, okay? Every agreement may not be a contract, okay? Every agreement may not be a contract, but every contract contains an agreement. And I asked you to explain this. Some people's explanation was all over the place. If you go back to the original definition of what a contract is, again, it has to be lawful. Okay, that number one, a contract has to be lawful, and it has to have consideration. Those are the two most important things that you're going to have that's going to differ a contract from a simple agreement. Okay, so an agreement is simply a decision by two or more people to do something without consideration. In other words, hey, let's just do this, and we agree to do it. Let's meet up tomorrow and go to the movies at 5 o'clock. If someone doesn't show up, Nobody can sue anyone. It was simply an agreement to do something. There's no consideration there whatsoever. As a result, the failure of one or more parties of the agreement to carry out the agreement has no legal consequence. On the other hand, a contract is an agreement for two or more people to carry out the terms of an agreement. They have undergone a bargain and exchange, usually of money. Money is the best form of consideration, okay, in consideration of the agreement. As a result, if one party fails to comply with that, they can be sued by the other party, okay? 10, mea culpa writ. This was part of your homework. It's simply an acknowledgement of guilt. As long as any answer that you had the word guilt in it, you got credit for it, okay? Number 11, interpreting legal documents. The definition of this course, okay, is defined as the process of correctly determining and understanding the legal, I put insignificance, and it's not that. It's the legal significance of the meanings, rights, and obligations and liabilities, okay, conveyed to one's self through a document or writing, right? And this word, I just corrected it here. This other word was also spelled wrong. Okay, this was not the word that I had in the original. Let's see what I had in the original one. Yeah, I had the word coveryed, Coveryed, No such word. That word doesn't exist. When I was putting this on the screen, I actually corrected it. But even if you didn't catch conveyed, insignificance, it changes the meaning of this whole document. Think of it. The process of correctly determining and understanding the legal insignificance of the meanings, rights, and obligations. So if you got this wrong, again, you didn't read the question with understanding, and that's what's going on here. 12, in our legal system, we went over this. The legislature writes the laws, the judges interpret them. Then the legislature rewrites the laws to conform to the judge's interpretation. 100% false. We said that before. We said that up in Albany, or for the state legislature, or here in New York City, the city council, they make laws. They write laws, okay? But those laws, they're just a barefaced law, okay? I told you, burglary, the unlawful entry years ago into the dwelling of another at midnight, at night, okay, with the intention to do a crime, to commit a crime therein. Okay, that was the law as originally written. So people started doing burglaries, in broad daylight, right? Breaking into people's homes in broad daylight. And the lawyer would argue, well, you can't convict them of burglary because the original burglary statute says it had to be at night, and it wasn't at night. So they clearly didn't commit a burglary. The judges interpret the law to say what the intent of the legislature was to actually stop burglaries, okay, and to charge people with burglaries when they commit them. They weren't making a distinction about night or day. Obviously, at the time they wrote them, it seemed to be that, I guess, it was happening more at night than the daytime. So the law was interpreted. The actual law was simply interpreted, and that word was removed. Now it's the unlawful entry into the dwelling of another with the intent to commit a crime therein. Okay, it's the legislature didn't change that. They didn't take those words out. The court's interpretation of the original law, based on what's happening, is what resulted in that change. Okay, so if it were to stop here, in our legal system, the legislature writes the laws, and the judges interpret them. Stop. That would be true. The rest of this makes it false. $13, Bill promises to shovel snow in Mary's yard for $20 every time it snows this coming winter. Winter comes, it did not snow the entire winter. Contract or agreement, okay? Again, there's two ways to look at this. Depends on how you argue it. Can Bill sue Mary? Why or why not? Well, Bill cannot sue Mary because the condition that triggers Bill's responsibility is the requirement that it snowed. If it did not snow, Bill's side of the contract, it never kicks in. That's a condition precedent. It never kicks in. So Bill can't sue Mary because Mary has no control over the over the weather. Okay. Some people could argue this was simply an agreement because there was no consideration. However, there's an argument on both sides that it could simply be a contract as well, because if for that whole winter, Mary Mary did not contract with someone else to come and do the work, to come and shovel the snow, but relied on Bill. Her expectancy was that Bill would be compliant and would live up to the his side of the agreement. So, agreement, contract. This one can go either way. I gave everyone credit for that, no matter what side you took. Explain consideration. Consideration is generally financial, and it involves a promise to perform a specific act or refrain from doing something. Okay, for it to be effective, every party to the contract must receive some type of consideration. Okay, if I buy something from you, you got the money. That's your consideration. I got the item. That's my consideration. Okay, there's usually a bargain and exchange, and that forms the basis of it. Can reliance or detrimental reliance be considered a form of consideration? Yes. Okay. This is what we've been talking about the entire time. Reliance or detrimental reliance can be considered a form of consideration, because if someone gives up a right that they have in reliance on someone doing something for them, right? That is a form of consideration, and it can be compensated if that is not done. Now, with respect to these the contracts, these definitions, this is simply your homework. Okay, if you did that, so again, if you just did the homework and just wrote the definitions down, you took it out the book and you really didn't pay any attention to it, then you didn't know what these things are. But again, if you took it out the book and you actually, read it, went over it, absorbed it, then you would know what these things are. Okay, so that is the all right. So that is essentially my going over the quiz. The next one is not going to be this format. It's going to be in a format that's mainly essay writing. It's probably going to involve that fact pattern we went over, where that person's home was burnt. That guy was trying to burn down the home because of his wife's putting the shoes in the garage. That will probably be the type of question that you'll have, and questions relating to waivers, which will be in another segment coming up after I take a break. All right, thanks.